where we would argue you can potentially get the best of both worlds is to, in addition to having the will, because the will gives a pretty good outcome there. You've achieved tax-free, stamp duty-free. You've got it into testamentary trusts. It's a pretty schmick outcome, and you've delayed any other transaction costs till as long as you possibly can because someone's actually passed away. But the big risk is you've got the challenge risk, and then you've got the people might be changing it. So I'd actually put that as step 5, that someone might change their will. Now, on the basis that scissor, paper, rock says that a contract beats a will, then is another idea to, in addition to having the will, having a contractual arrangement in place between the up-and-coming generation and the holders of the assets already. And that option might look like the following. It might be a call option. It might have a $1 strike price. If it ever does need to be exercised, and why would it need to be exercised? Well, because the will didn't say the right thing, or the will was challenged. On the exercise of that option, the market value substitution will probably apply, because they'll argue you've not necessarily been acting at arm's length. That will give the continuing owner the right cost base. Interestingly, it'll then trigger a tax bill back into the estate because they've potentially sold an asset outside the will and received a market value for it, and that opens up a whole range of quite interesting discussions. The downsides are that for it to work, the conservative view is that each party must get independent legal advice, and that can be a lot easier said than done, particularly if you're acting within the one family unit. The other big downside is that because the asset's effectively going to have been dragged out of the will, because the option's been exercised, there'll be no access to accepted trust income. So you won't actually get access to that nice outcome that you would otherwise receive if the shares could have actually fallen in under the will and formed part of any testamentary trust set up there.